see her come running in here, all disrupted.
She's in bankruptcy court and
Is Mr. Thompson and Judge Burmester's going?
Sir, can you tell me your name, please?
Douglas Webb.
So, wait, Mr. Thompson, you done next door? All right, Mr. Thompson, are you ready on Mr. Martin's case?
I am, thank you.
Okay, People versus Dean Martin, case number 235199.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Dean Martin. Your Honor, the court had adjourned last time. The court had adjourned last time because we had a pending plea offer that we wanted to take advantage of, which was that Ms. Coke had offered that if Mr. Martin pled guilty, to count one, operating while intoxicated, it would be taken to a second offense notice as opposed to a third offense, taken down to a misdemeanor if he attended a rehabilitation. Mr. Martin has now achieved health insurance, which is necessary, and is on a waiting list at rehab. So we believe that will occur. I don't know if the court would prefer to take the factual basis today and then it's sentencing determine if the rehab condition's been met such that can be entered as a second instead of a third, or the court would prefer to hold back on taking the plea because the exact nature of the conviction would be known at that time. But we've made that amount of progress, and we're very happy with Mr. Martin. He has health insurance now. He's on that waiting list. He should be in Cascade Hall fairly soon.
All right, Ms. Coke.
Yeah, I think procedurally it makes sense to have Mr. Martin plead to the OWI second today, based on the agreement that he goes into the rehab facility. We'll set the sentencing out, if the court will allow, till January. And then if he does not get into that rehab program, we would be allowed, or he would be required to withdraw his plea. This way, then he could just be sentenced and we can move forward. It's been pending for a long time. And I think that would be best for Mr. Martin. I know that he's been working hard to get this rehab program. We've had lots of conversations about it. So I think he should be allowed to take advantage of that plea offer. And if he doesn't get in, we'll withdraw the plea and start over. But I think he's in. I think we've got this one.
I believe my client would be prepared to make those admissions and make that plea today. Then, yes.
Okay, Mr. Martin, is that how you want to proceed today?
Yes, sir.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
Mr. Martin, are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to operating while intoxicated, second offense, but that's a misdemeanor that carries with it a maximum penalty of up to 1 year.
Yes, sir.
With that in mind, what is your plea to that charge today?
I plead guilty.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all of those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights.
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty? Anyone promised you anything other than what we said here in court today? Is it your own free choice to enter into this plea?
Yes, sir.
Plead guilty because you are guilty.
Yes, sir.
This happened in April of this year, April 16th. Is that the correct date?
Yes, sir.
On that date, had you been consuming alcohol?
Yes.
And after you consumed alcohol on that day, did you operate a vehicle on North Downriver Road here in Crawford County?
Yes, sir.
Okay. At the time that you were operating that vehicle, had you consumed enough alcohol that you believed that you were intoxicated?
I didn't know I hadn't drank that much until after everything played out. But I thought I was under the limit, but obviously I wasn't.
Okay. Do you know what the testing showed for your blood alcohol level?
I think it was 0.16 or 7. I can't remember exactly which one.
Okay. Do you have any reason to doubt the accuracy of that test?
No, I went to the blood test. I know it must be accurate.
Okay. Had you previously been convicted of operating Robbery while intoxicated back in 2001 in Livingston County.
It was actually, that's when the fine got paid off. The actual DUI happened in 95.
Okay, but you do have at least one prior conviction.
Yes, sir.
Ms. Koch, are the people satisfied with the factual basis?
Yes.
Mr. Thompson?
Yes, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Thompson?
No.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in taking the plea?
Yes, Your Honor.
Yes.
Mr. Martin, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing in January. Before you leave today, you're going to meet with Mr. Haven to set up a pre-sentence report. And then just make sure that you stay in touch with Mr. Thompson so that you're prepared for that sentencing hearing once we have that scheduled, but you'll get notice of the date and time of that in the mail. Okay.
Okay.
Thank you.
All right, thank you, sir.
People versus Webb, case number 235246.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Douglas Webb. Your Honor, in this matter, the prosecutor has made a new plea offer. The plea offer would be to maintaining a drug car, which is the same as maintaining a drug house. That's a 2-year. It's one of those difficult to describe statutes that both the high court misdemeanor and treated as a felony for certain purposes. It's a 2-year maximum. I believe Mr. Webb wants to take advantage of that, but it's a fairly recent offer, so I'd ask the court to ask him.
All right. First, Ms. Koch, is that a correct statement? We offer.
It is, Your Honor. The PAT code for that is 333.7405D. The maximum penalties are 2 years and or $25,000. And that is a correct statement of the plea offer.
Mr. Webb, have you had a chance to talk to Mr. Thompson about this plea offer? Did you want to go forward with that today? Okay. You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. I'm sorry. I need you to. Can you repeat it, please? I do. Okay, thank you. I'm tired of this. All right, Mr. Webb, are you currently on any probation or parole? No. And as Ms. Koch stated, the maximum penalty for this additional count 3, which is maintaining a vehicle for the use of drugs, that is up to 2 years and or a $25,000 fine. With that in mind, what is your plea to that charge today? Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all of those rights. Yes, sir. You understand that you're going to be giving up and waiving all of those rights, including the right to have a trial. Yes. Also, if you wanted to appeal the plea that you're making here today, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that? Yeah. Has anyone threatened you with anything to get you to plead guilty? No. Has anyone promised you anything other than what we've said here in court today? No. Is it your own free choice to plead guilty? Yes, sir. Are you pleading guilty because you are guilty? Yes, sir. Great. Given the charge here, and Mr. Thompson, can you do some questioning of your client to establish the factual basis?
Certainly, Your Honor. So, Mr. Webb, you were arrested on, I believe it was June 1st of 2023. Were you in a vehicle that day? Yeah. All right. And you agree that the police found cocaine in that vehicle? Okay. That's what I was checking. Yep. And you agree that you knew that that car was being used for the purposes of transporting or storing drugs?
I didn't know that. I wasn't driving the car.
Okay, so you don't admit that you knew about the drugs in
I
the
didn't
car?
know.
All right, Your Honor, I don't believe there's factual basis. I'm sorry.
Oh, I don't know what the elements are. Are there any other questions that you wanted to ask?
Let me ask, Mr. Webb, you were riding in a vehicle with other people? And there were drugs in that vehicle, even if they weren't your drugs?
I basically, I
And you were aware that those drugs were in that vehicle, even if you were not the owner of those drugs?
wasn't aware.
Your Honor, we can't enter the plea.
Okay. All right, Mr. Thompson, how do you want to?
I would like an immediate trial, Your Honor. Mr. Webb's been lodged since he was arrested in June. We're getting close to 180 days here. So I'll file a motion at that time, obviously. And trial is try to have a trial.
All right, Ms. Cole, how many days?
I'm sorry.
1 day. Yes, so we agree with that.
I would, Your Honor.
All right, so we'll set it for a 1-day jury trial at the court's next available date. The court will set it for a final status conference prior to. That will be plea and motion cut off. Spoke any other dates that need to address?
No.
No other dates other than just alerting the court when we hit 180 days here, which would be approximately December 1st. I will be filing a motion to have this bond reduced to a PR bond.
All right, very good. Thank you. That's all for today.
Thank you.
Mr. Trush, are you available to handle Ms. Guggen's case?
Yeah.
Ms. Guggen, if you want to come up to the podium. We're on the record in People versus April Guggen, case number 225027 and 235241. The record should reflect Ms. Guggen's present here in the courtroom today. Mr. Trush, if you could put your appearance on.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Guggen.
Sierra Coke on behalf of the people.
Thank you. Mr. Trush, can you tell me where things are at with this file today?
Actually, Your Honor, we had 2 files before the court today, I believe.
Correct. I misspoke. These files.
We do have an agreement whereby Ms. Guggen would be admitting to possession of methamphetamine in one file and a use of methamphetamine in the other. And then once we complete the plea, I do have a bond request to the court as well.
Okay, each file has one charge of possession. One occurred on December 25th of 21. The other occurred on March 31st of 22. Do you know which one would be the plea to the lesser charge of use?
The lesser charge of use is 22.5 or 225027 FH, and the possession of meth is 235364 FH. There's an additional agreement that we would not charge her with absconding on bond.
Okay. Mr. Trush, is that your understanding?
It is, Your Honor, and I apologize for the confusion. The case numbers that I have on the plea sheet, we didn't have the district or the circuit court case number for one of those cases yet.
And use is a 1-year misdemeanor.
It is, Your Honor.
All right, Ms. Guggen, have you had a chance to talk to Mr. Trush about this plea agreement?
Yes, Your Honor.
And is that how you want to proceed today?
Yes, Your Honor.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Ms. Guggen, are you currently on any kind of probation or parole?
No.
And you understand that you're pleading guilty to 1 count of possession of methamphetamine that carries with it a maximum possible penalty of up to 10 years and or a $15,000 fine. You understand that?
Yes, Your Honor.
And you're pleading guilty to 1 count of use of methamphetamine, and that is a misdemeanor that carries with it a maximum penalty of 1 year in jail.
Yes, Your Honor.
With those penalties in mind, what is your plea to each of those charges today?
I choose guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. And you have all of those rights.
Yes, Your Honor.
Understand you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to plead guilty?
Yes.
Are you pleading guilty because you are guilty of each of these crimes?
Yes.
Okay, so starting with the older one, that was back on December 25th of 2021. Do you recall that date? Is that the correct date?
Yes, sir.
On that date, were you here in Crawford County?
Yes.
And on that date, while you were here in Crawford County, did you use methamphetamine?
I did.
Do you have a prescription or any other legal right to use that substance at that time?
I did not.
Then moving forward to March 31st of 2022, do you recall that day?
Yes, Your Honor.
On that day, were you also here in Crawford County?
Yes.
And at that time, did you have possession of some methamphetamine?
I did.
Did you know that that's what that was?
I did.
Did you have any legal right to have that at that
I
time?
did not.
Thank you. Ms. Koch, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Trush,
We are satisfied, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Trush,
More of none, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Trush, are you?
Yes, Your Honor.
Ms. Coogan, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as a whole. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Somebody from the probation department will be in touch with you to do a pre-sentence interview. Ms. Koch, is there anything further we need to address on this file today?
No.
Can I add some?
Mr. Trush?
We did want to address a bond issue to the court if we could.
Okay.
So Ms. Guggen's situation is somewhat unique. It's unique in the sense of before she became incarcerated, but after the second offense occurred, she recognized that she had a problem. She checked herself into a rehab and completed 30 days of rehab before ultimately addressing the bench warrant and becoming incarcerated. As a result of that, she's gone through a rehab, and the court, I'm sure, is aware that we often will ask for the court to consider allowing someone to be released into rehab for those purposes. Ms. Guggen's already completed a 30-day rehab. She's been sober for about 6 months and has been incarcerated in the jail for some time now. I believe there is someone there from a CMH diversion program in the courtroom, but ultimately we'd be asking the court to consider amending her bond to allow her to be released into a sober living home. We believe that she can get a bed in a sober living home. And we'll be able to kind of pick back up and jump back into her recovery program. I would indicate, based on our calculations, I think she's going to have about 60 days that she's been in the jail at this point. And given again, sort of the nature of the pleas and lack of criminal history, I think it's likely that at sentencing, she'd be looking at a time served sentence anyway. My suggestion to the court would be we're better served by, again, jumpstarting that recovery process as opposed to delaying it.
Have you done a preliminary scoring of the guidelines, Mr. Trush?
I have not, Your Honor, but again, ostensibly, I don't believe she has any scoreable prior history, which would put her on an intermediate sanction at a 0 to 9 or 0 to 11, most likely.
All right, thank you, Ms. Coe.
Your Honor, I would ask that she remain incarcerated until her sentencing. She absconded on her first case. She failed to appear in May 16th. She wasn't arrested on that bond until 10/2/23. The fugitive team, I know, looked for her numerous times. I don't know how they pick who they looked for, but they looked for her. They even came in and met with me about looking for her over several months. I understand she went to rehab at the end of that, but she was on a failure to appear for a long time. I think she should remain in there until we get to the 30 days. I have talked to CMH about a diversion. I did explain that because we had this absconding, I wouldn't agree to that at this early of a stage. And I would be objecting. Her criminal history, I don't know exactly what it is, but it's a 2006 disturbing the peace, a 2011 no license, a 2007 no license, a 2013 DWS, a 2014 DWS, and then in 2014 she used her 7411 on a drug case. I'm not sure. I didn't write what type of drug case it was. So I would ask that she remain incarcerated just until our sentencing, and then we can deal with her sober living and CMH issue at sentencing. Given her failure to appear for 5 months previously. Thank you.
Ma'am, are you here as part of the diversion program? Is there any input that you wanted to have?
Just that I have talked to 1016 where she was previously in rehab to complete that program, and we have kind of spoken. She's completed the application for the sober living facility. I don't know the status of that application at this moment.
All right, I agree with the prosecutor. I think we need to get to the sentencing phase. I absolutely would consider rehabilitation or some type of program as part of sentencing in this case. I think that would be helpful. But I agree with the prosecutor. I think we need to get to that spot first. So the court's going to deny any release at this time, and we'll get scheduling sentences. Thank you.
Say something real quick.
What's that?
Can I say something real quick?
Sure.
I just want to say, I'm sorry, you guys. I'm really sorry. I don't know how it happened. I just got sucked in, and I had to get out of railing to get sober. So I went to rehab, and I've been trying to get in sober living, but I had this warrant. I'm glad it's almost over. I don't mind sitting until whatever sentencing.
And you'll have a chance to explain more too at the sentencing hearing.
Oh, okay,
So thank you.
thank you.
Hey, Your Honor, is Mr. Quinn present by any chance?
Mr. Quinn here? No.
Okay, I will log back in then. Thank you.
Okay, thank you. Mr. Thompson?
Mr. Baker here is last known. I don't know, if it's still lodged or out. Mr. Baker.
Last I knew he was lodged, it was
Still?
yeah.
Do you have your 9:30 ready, Mr. Thompson?
Yes, Mr. Grigsby's here in the court.
Okay, we'll call that case. People versus Grigsby. This is case number 235221.
Sierra Coke on behalf of the people.
Go ahead. Thank you, Your Honor. Jason Thompson, that defendant Brian Grigsby. Your Honor, I agree to set this trial.
All right. I just want to make a record, has there been a plea offer in this case?
There was a plea offer. It was attempt CSC fourth. Defendant rejected that. This has been going on for a while. We ran a preliminary examination. We are prepared for trial. I anticipate trial being one day.
I think we can get this done in one day. Yes, Your Honor.
So we'll set for one-day jury trial. Ms. Coe, do people need any particular period of time to be prepared for trial in this case?
No, we're prepared. We can get this set as soon as possible.
I would agree, Your Honor.
Okay, so we'll set it for a one-day jury trial at the court's next available date. As usual, the court will set it for a final status conference prior to trial date. That final status conference will be the plea cutoff. Ms. Coe, are the people anticipating any pre-trial motions?
I don't think so.
Mr. Thompson?
At this time, I'm not. I will review and make sure we don't need anything other than the rape shield law.
Okay. To the extent either party does, those motions should need to be filed within their status conference. So any other dates I can address for the people?
No, thank you.
Mr. Thompson?
No, Your Honor, thank you.
Mr. Grigsby, did you have any questions?
No, Your Honor.
So just make sure that you stay in touch with Mr. Thompson. We'll be sending out the date of the trial as well as the final status conference by mail. But again, just make sure that you stay in touch with Mr. Thompson.
Yes, Your Honor.
That's all for today. Thank you.
Thank you. And we don't yet have Mr. Baker, right?
What's that?
We haven't connected with Mr. Baker, right?
I do not see.
All right, I'm gonna take a moment with Mr. Grigsby, and I'll be in the hall if he appears.
Court will take a recess until
I can call.
10 o'clock.
Thank you, Your Honor.
on that one over there.
Okay. So I'm gonna turn this off.
When they say my court hearing was,
10:30.
okay, so I got 25
A few
minutes.
minutes, yeah.
Good, I can go over my
If-
thing.
If you have trouble hearing them now, just rap on the door and let somebody know, okay? But I have turned the volume up on the television.
Okay.
Mr. Wilson, are you able to hear me okay?
Yes, sir.
All right, I'm gonna put you in the waiting room for that. We have your hearing scheduled for 10:30.
Is there any way I could speak with my lawyer before court?
Yep, I can have you guys put into a waiting breakout room so that you can talk to them. So I will
Please,
do
thank
that.
you. Please and thank
No
you.
problem. No problem.
So polite. So polite.
Are you Mr. Quinn? Yes. Oh, Mr. Quinn, if you want to come right up to the podium. Mr. Trish, we have Mr. Quinn present, so we're going to go on the record in that file. This is People versus Matthew Quinn, case number 235208. The record should reflect Mr. Quinn is present here in the courtroom. If counsel could put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Quinn.
Mr. Trush, how did we want to proceed in this file today?
Thank you, Your Honor. We had asked the court previously for some time so we could put together some restitution on, we've had discussions with the prosecutor of potential dismissal. As of this time, I think we're getting close to it. We're not quite there. I would suggest to the court, though, kind of given the age of this case, that we look at getting the matter set for a trial. I'm still optimistic. I think that we're going to be able to get something done short of that. But again, kind of given the age, I think it's probably prudent for us to be moving it along.
It looks like we also had this set for a show cause based on Mr. Quinn's failure to appear back in September. Mr. Quinn, can you talk to Mr. Trush about that, or
I have, Your Honor.
what happened back in September?
I blew the transfer case out of my truck and could not, the day before, couldn't get here. Fortunately, I thought I had a ride already until the morning of, and I lost it.
Okay, you did try to log in.
I did, Your Honor.
Okay, in terms of how to go forward, Ms. Cope.
Your Honor, I did make an offer in this case. I would dismiss the case in full if he paid the restitution in full. It's a high restitution amount. I can't remember the exact amount, but it's over $50,000. I think it's $62,229.55. I think that's what my notes here say. So our goal is to get that paid off. If he does pay that off, he's trying to do something with his father's estate. I'm not sure exactly what it was. I talked to defense counsel about it. If the court wants to adjourn it out, if they think they can have it paid within a month, we can do that and not set it for a trial. Otherwise, I'd say put it on the trial docket and set it for a final status conference and see where it comes in.
All right, I think I want to get this on the trial list so that we have an end date that everybody's working towards. And if it's paid by that date, then, you know, whatever you have worked out with the prosecutors, what's worked out. If it's not, then we have the trial date to get the matter concluded one way or the other. So, Ms. Cope, do you need any particular period of time to be ready for a trial in this case?
No, we're prepared for trial now. We can get it set.
How many days of trial do you think this will take?
One.
Mr. Trush, do you agree with a 1-day jury trial?
I think that would likely be adequate.
And Mr. Trush, is there a period of time that you need to be prepared to go to trial in this case?
I don't think anything outside of the court's normal scheduling is necessary.
Okay, so we'll set it for a 1-day jury trial. The court will set this for a final status conference prior to that. That'll be the motion and plea cutoff. Mr. Trush and Mr. Quinn, if you're able to, if we have a resolution prior to the date of that final status conference, then just let the court know, Mr. Trush, and we can get things set for hearing if we need it, or Ms. Cope just file a nollie and we can have the case concluded.
Okay, thank you.
But otherwise, the next hearing date will be the date of the final status conference, right before trial. So Mr. Quinn, just make sure that you stay in touch with Mr. Trush.
Yes, Your Honor.
Given that Mr. Quinn doesn't have any prior failures to appear, the court isn't going to impose any additional sanctions for the September hearing. So it'll dismiss the show cause. Ms. Koch, anything further that we need to address for the record today?
No, Your Honor, thank you.
Mr. Truth, anything else we need to address on the record today?
No, Your Honor, thank you.
All right, thank you. That's all for today.
Your Honor, hunting season is starting, and I talked about it with my attorney about getting permission to have my firearms during firearm deer season.
That is correct.
I'm sorry, what's that?
That is correct. I forgot. We did want to address that to the court.
All right, that's something that you can work out an agreement with the prosecutor's office, make the stipulation to allow that. I don't have a problem signing the stipulation, but otherwise the bond conditions, they are what they are, so.
Understood.
Okay. All right, thank you.
Thank you.
Thank you.
All right, our next hearing set for 10:30.
On these TVs, you just see single cheese.
Are you talking about Wilson?
Yeah.
Yeah, are we gonna do anything with?
I love
Are
that.
those yours?
Yeah, I don't believe it.
Could we do the
I
county
like
sentence
it.
first?
For a year.
Oh, give her what it expected.
I don't believe anything. So I do different stuff. We're actually.
I don't care much for super chewy stuff either.
I did.
Or hard candy or chocolate. You got chocolate. Then we're talking. I can see that. What do you say? We're off until 10:30?
Get involved in these.
Yeah, they're about-
But the amount of money here.
I know, it's more than
It's crazy, so, I have talked to the attorney numerous times. We have like 12 trials ahead of it, so there's no matter when we get it scheduled, but, we are caught up in 2021, 2022, so that's good.
nice.
Yeah, that COVID pushed us back, like, it used to be we could have a trial in like 6 months, but now it's like.
It's crazy that he gets to hunt, he gets to have
Well,
some
yes.
privileges.
He's not putting the hunt, I'm not saying that.
Thank you.
So,
I mean, I have been discomfort in my family, has been discomfort, it'd be nice if he was a little bit discomfort. Besides those few days in jail.
I would really, well, I think it's.
Yeah.
Prison, so.
Yeah.
I think his okay, because prison is more incentive than a civil case.
Yeah, absolutely, absolutely.
That'll usually get somebody going,
Okay.
so hopefully
I
he
hope
gets it
so.
paid. Did I get the amount right? I wrote my notes on.
Yes,
it, but-
I believe so, I just, yeah. I
Well,
believe so,
my
yeah,
truck,
exactly.
I charged it 20 to 50,000, we got more information. And
Yeah,
I said if I go to trial, I can upcharge this.
Yeah.
I was attorney, so,
yeah,
yeah, we try not to get involved in these type of cases. but
I
this was-
know.
But this was so much, I was like.
that's what my husband said, his good friend was for the state.
They said most was
He
prosecutors.
said, yeah, this is a rare thing, but
I do it.
because of your amount, you may have a chance.
I have done it for, even I did it for an elderly lady who the guy put it in wrong. It was only $9,000. He put it in wrong and it got,
Like more damage.
no, he it was a, had a HVAC
Oh, yeah,
system and it almost killed him. He was hospital 3 times.
Apparently the courtroom was live.
that's fine.
And we charged that one.
Okay.
So that was kind of crazy. So we charged a few of them where they were like really big amounts or had experience
Right.
circumstances for like that.
We really appreciate the work. It's just very frustrating.
Mr. Dermurthy, are you able to hear me okay?
Yes, sir. Thank you.
Okay, we've got Mr. Trombley present here in the courtroom today, and we're on the record in People versus Trombley, case number 235197. We have Mr. Dermurthy on behalf of Mr. Trombley present here by video. Ms. Koch is present in the courtroom. We're here today for a show cause hearing based on Mr. Trombley's failure to appear for required drug screenings in August and October. Mr. Dermurthy, have you had a chance to speak with Mr. Trombley about this?
I did, Judge. I spoke with Mr. Twombly. Mr. Twombly has an explanation. Mr. Twombly indicates he was working downstate and had no way to get up here for those 2 drug screens. So he did miss those 2 drug screens.
All right, Ms. Koch, how do the people want to proceed today?
Yeah, we would ask for his bond to be revoked, which is typically what we would do. We would have filed a motion and asked for his bond to be revoked. I guess if he's in jail, he'll find a way to comply with the bond conditions that this court set, but it's been months. Ms. Anderson, I don't know if she's present today, but she sent us an email that he's failed to contact her. She's tried his roommates. It's the only number he gave. She's been going round and round with this. I believe this is the 2nd or 3rd time that he's failed. Based on her notes, if she's present, she can probably give a better dissertation of the number of things he's missed. His CCH includes a domestic violence in 2003, 2013 felony assault with a dangerous weapon, and a 2015 CSC second. I think it's appropriate to lodge him on this violation.
All right, Mr. Trombley, maybe you sit down for 1 second. Testimony from Ms. Anderson. Ma'am, if you would come forward, please. Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. Thank you. Ms. Koch, you just made some representations there. I'm wondering if you can ask those questions, Ms. Anderson.
I didn't see her sitting behind me. Ms. Anderson, what is your title here?
Pretrial services case manager.
And when was Mr. Trombley assigned to you?
I would have to look to see what the date it was exactly.
Okay. Have you,
Mr. Trombley, I can't have you contributing to that, so.
have you been in contact with Mr. Trombley?
Up until August,
Okay. And what happened in August?
when he was called in for the drug test at the end of August. He was a failure to appear. I never heard from him. I didn't act quite on that one. My work phone had gotten shut off for a couple weeks and there was no way to get it turned on. So I didn't act right away on that one. As soon as it got turned back on, I tried contacting him again. Then missed the drug test in October, beginning of October. Again, still trying to contact him, never heard from him. Then he did miss a 3rd test at the end of October as well. And the same thing. I've yet to hear from him.
So he's been absconding for 3 months.
Approximately, it's definitely September and October.
And has he tried to reach out to you at all?
I have not got any communication.
If he had asked you if you could take a test at a different location, would you have helped him arrange that if he was working out of the area?
Yes.
And did he do that?
No.
Thank you. No further questions.
And you may have already answered this. Did you make attempts to contact Mr. Trombley at his last known phone number?
Yes, which I believe belongs to his roommate. So I would text and call.
But you weren't able to reach him.
No, I would talk to her quite often, but never got a response from him.
All right, thank you. Mr. Dermurthy, did you have any questions for Ms. Anderson?
I do, Judge. Thank you. Ms. Anderson, did Mr. Twombly's roommate indicate that he was out of town and working downstate?
On the 3rd missed test, yes. And it was asked if he could test when he got back in town the next day. I responded no, that he needed to find a place to test down there. And I never heard back on that.
And you had good contact with Mr. Twombly up until August, is that correct?
Yes.
And he hasn't had any dirty drug screens up until August, is that correct?
Yes.
And you would be able to drug test him today if that was ordered by Judge Mertz?
Yes, it was actually texted to him here yesterday as well to test when he came to court.
Did you already test him this morning?
I don't believe he stopped by the window to test, no.
Okay, but you were able to do that today then, correct?
Yes, yeah, it can be done today.
Okay. I have nothing further, Judge.
Okay. How long would that take? to administer the test and get a result?
Probably about 10, 15 minutes.
Okay.
Just-
All right. Mr. Tremley, I'm gonna have you do that test here this morning, and Ms. Anderson, if you can report back to the prosecutor what you have a result, or to actually you can let Sarah know, once we have a result, then we'll recall.
Can I say something? The third one that supposedly you told me I could go anywhere, I went across the street to where I live, Roscommon County Police Department. Todd Contrell denied my drug test.
Are you gonna test positive today?
No.
Okay. I know. Take the test and fortunate enough to decide what to do once we find out test results after that. All right, so we're gonna pass this matter for right now. You go ahead with Ms. Anderson. Mr. Gurmurthy, I do have Mr. Wilson. He's indicated that he wants to have a chance to speak with you, so I'm gonna bring him in and have you have a breakout room with him. Do you have any idea approximately how long you're gonna need to speak with him?
I would need, I would think no more than 10 minutes, Judge.
Okay.
They're
Right,
just
Mr. Wilson.
with the prison trying to get him with Zoom on me because he was quarantined in Jackson.
Yeah, that's no problem. I'm just trying to get an idea of whether I should just stay here on the bench or take a break while you're speaking with him. So I'm just trying to get a sense of how much time. Mr. Wilson, I'm gonna put you into a breakout room with Mr. Gurmurthy, okay?
Thank you, Your Honor.
And Mr. Gurmurthy, it's 10:40, so I'm gonna plan on coming back on the record at 10:50, so that'll be about 10 minutes.
Yes, sir.
Mr. Yeah. That in there.
All right, Mr. Wilson, are you able to hear me okay?
Yes, can you hear me?
I can, thank you. All right, we're on the record now in People versus Wilson. We have a number of files up for hearing today. I'd like to start with the newer files related to sentencing, and that is file 235240 and 5241. We also have some probation violation files that we're hearing, but I'd like to address the sentencing first. I can have both counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Honor Rabbi Murthy. I'm appearing on behalf of Mr. Wilson. I'm appearing by Zoom. Mr. Wilson is also appearing by Zoom. And Mr. Wilson does not object to proceeding to sentencing by this manner.
Thank you. This is the date and time set for sentencing in this case. Mr. Wilson, have you had a chance to go through the pre-sentence report with Mr. Gurmurthy and talk to him about that?
Yes, Your Honor.
Are you ready to proceed with sentencing at this time?
Yes, Your Honor.
Thank you. Mr. Gurmurthy, are there any additions, deletions, or corrections to the report?
No, just for the record, I did send the pre-sentence report to Mr. Wilson. He did get a copy of his entire report. So I just want to put that on the record. And then we did review some of the contents of the report. And based on that review, we don't have any additions, corrections, or deletions to the body of the report.
Thank you. Do you have any challenges to the scoring of the guidelines?
No, sir.
Ms. Pope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do the people have any challenges to the scoring of the guidelines?
No, I think they're correct.
Anything on behalf of the people for allocation today?
Your Honor, we're going to ask the court to sentence Mr. Wilson on the high end of both cases, which is 23 months and 24 months. And I'd ask the court to do consecutive sentencing. The court is very familiar with Mr. Wilson at this point. You know, he has a prior, I think he previously had to be extradited from Florida. And we had the cases where Your Honor gave him a great offer. I think I was looking to look at my notes, but I think we may have even went under the guidelines last time when he had 5 felony cases here and 2 were dismissed and he had 3. The court gave him a year in jail. I remember us talking about his work ethic and how he was trying to get clean and do the right thing. Since then, he's had 12 probation violations on his other files. Between the 3 counties, he's got felonies everywhere. He absconded. The court's aware of how he absconded. Hours and hours of time were spent trying to locate him and to follow up on the forged letter that he provided, because he didn't just abscond. I don't know who forged the letter, so he wasn't charged with that, but a letter was provided to this court and the other courts with this forged signature. Mr. Wilson has earned a prison sentence. I don't think boot camp is appropriate for Mr. Wilson. I'm surprised he hasn't been to prison yet, but he has 6 prior felonies, 22 prior misdemeanors, and a juvenile record, and he's only 34 years old. So I'd ask the court to sentence him on the high end of the guidelines. And I believe based on the fact, all the facts that the court's aware of, consecutive sentencing is absolutely appropriate. Thank you.
Thank you, Mr. Gurmurthy. Anything on behalf of Mr. Wilson today?
Yes, Judge. Mr. Wilson is 34 years of age. Mr. Wilson, as the court is aware, has a prior criminal record. But I think the court should know where Mr. Wilson currently is. I think he's in a much better state of mind than when these offenses were committed. As Mr. Wilson states in his pre-sentence, that he knows he messed up. He knows he got into these criminal charges because he was not in the right state of mind. But I think since then he has cleaned up his act. He resolved all of his matters pending in different counties in Roscommon, Otsego, and Crawford County. Mr. Wilson, I don't believe is eligible here for a consecutive sentence, but I don't believe even that the offenses are that severe, given that they should warrant for consecutive sentence. The idea with Mr. Wilson at this point would be to punish him for the crimes that he's committed, but also give him that opportunity to rehabilitate himself. I understand there have been some prior probation violations and the absconding issue, but I think that's all in the past for Mr. Wilson. He accepted accepted the plea, accepted the sentence that would come with him, knew at the time of the plea that this would come with a prison sentence. But Mr. Wilson is asking that the court give him that opportunity to rehabilitate himself, give him that opportunity to show that he is going to work through programs while in prison. He is eligible for boot camp, that the court grant that boot camp eligibility. Certainly the court doesn't have to grant it right away. The court could grant it, 14, 15 months out after he does a prison sentence, and then reintroduce him into the community. Because again, while on boot camp, he would be on a parole detainer status where he still has to, behave while he's out. And if he violates, he goes back to prison. He has to then finish up his term and potentially have new charges that would then be consecutive to his parole status. So there's a lot of, I think, benefits here for Mr. Wilson, that if the court does grant the request for boot camp, that he doesn't mess that up. He doesn't make that worse for himself. But that would be the idea, is to give him that opportunity for rehabilitation. I know part of this plea agreement was that the misdemeanor file would be dismissed and that there be restitution ordered to Ms. Brandy Welch. Mr. Wilson does not object to that restitution amount. And I did submit some letters on behalf of Mr. Wilson that he has support of his family and family members around. So I would ask the court to give him that opportunity towards rehabilitation by granting him boot camp after a certain time frame that he does while he's in prison, and get some classes and some other skills under his belt. That's all I have, Judge.
Thank you. Mr. Wilson, was there anything that you wanted to say here today?
Well, I don't agree with what was said at sentencing yesterday, as all the mothers of my children would feel the same way as Mr. Zinsky, because I do support my other two children regularly. I don't have warrants. I've never been to jail on those matters. I'm finally admitting I have a problem and taking responsibility. Normally I would be in jail. I would tell myself, how can I hide it better? How can I get away with it? That's not the case this time. I just simply don't want to go down the same road over and over. If rehabilitation is what's needed, and clearly my drug addiction is the problem, how is a long prison sentence what's needed for my recovery? As I've been here for almost 2 weeks and I've been approached by inmates asking if I need or wanted prescription drugs, alcohol, meth, cocaine, heroin, and fentanyl, Suboxone. I believe the system to be flawed and boot camp to be a safer place. I do believe I need time to reflect. I also asked the judge to reconsider boot camp for its structure and discipline, and possibly be approved for it after I do a year in MDOC or even half my sentence. They have intense inpatient substance programs in the program. They require no sanction or tickets of any kind, and must complete all courses to graduate. And drugs and alcohol is zero tolerance, as they drug screen throughout the program, and inmates don't leave the compound as they do in prison. I've done my research on this, and I believe the program is the best interest of the court, my family, the homeowners I do work for, and also myself, and to show that I'm not just another statistic. And so I can prove to the courts and you wrong about who I am. Thank you for your time.
Okay, thank you. The court had a chance to review the pre-sentence report in these files here today. As Mr. Hold on one second. As Mr. Wilson, for the record, I'm just muting Mr. Wilson only because there's some background noise there. Mr. Wilson, if you need to address the court again, or want to, or need to speak with your attorney, just raise your hand and I'll unmute you, but there's a lot of background noise there that's interfering with the record. So again, the court's had a chance to review the pre-sentence report in this case. I'm familiar with Mr. Wilson. Mr. Wilson was in front of me yesterday for sentencing on some other files in Otsego County, and some of the statements were referring to the sentencing hearing we had yesterday. And I do adopt some of the statements that I made in the course of that hearing. Generally, Of course, the circumstances here are different crimes in a different location involving completely different circumstances. But I say that to say that I am familiar with Mr. Wilson, his past history, his background, as well as the cases here. Mr. Gurmurthy is correct. I did receive a number of letters on behalf of Mr. Wilson. I did have a chance to review those letters prior to the hearing today. Yesterday, one of the victims in one of today did speak favorably on behalf of Mr. Wilson in terms of some aspects of his character, in terms of his ability to work and so forth. So the court takes all those things into account along with what Ms. Koch has had to say. And certainly I you know, in this case, the court is looking more at a punishment aspect. I understand that may not, prison time may not result in rehabilitation, but I think given Mr. Wilson's conduct, that there needs to be a component of punishment and deterrence here. There have been numerous opportunities through probation, through community sanctions for Mr. Wilson to take advantage of programs to correct his behavior, and none of those things have worked. So in my view, it's time to try something different, and the only real option left to the court is prison time. Yesterday, I expressed that I didn't think boot camp was appropriate, and I continue to agree or feel that way. I think given the number of crimes, Mr. Wilson's past history, previous attempts at rehabilitation, at this point, again, I think the court needs to focus on a punishment forward sentence as opposed to rehabilitation. However, although I do think consecutive sentencing is allowed in this case, discretionary because of Mr. Wilson's bond status, I think there are mitigating factors here as reflected in the letters of support for Mr. Wilson. So while I don't think boot camp is appropriate, I also don't think the extreme sanction of consecutive sentencing is appropriate either. I think a sentence at the high end of the guidelines here addresses his previous conduct or his previous record and conduct, as well as his conduct in these cases. As to file 235240, the court will sentence Mr. Wilson to 23 months to 10 years in the Michigan Department of Corrections. Mr. Wilson on that file has 101 days credit. Restitution in the amount of $416 payable to the Crawford County Clerk. Crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to file number 5241, which is the absconding charge, the court sentences Mr. Wilson to 24 months to 4 years with credit for 56 days served. The crime victim's assessment of $130 and the state cost of $68. Those sentences to run concurrent to each other and concurrent to any other sentences that Mr. Wilson may be serving. Mr. Wilson, you will be provided with an acknowledgement of your appellate rights. Those papers will explain to you how to seek an appeal of these sentences, as well as how to request a court-appointed lawyer to help with any appeal. Mr. Gurmurthy, is there anything further we need to address in terms of sentencing on those two files?
No, Judge.
Yeah, and I just want the court to acknowledge on the record so that we have it for the record if we need it. These sentences are concurrent to both Roscommon and Gaylord's prison sentences. They have to be because this was first in time anyway, but I think we have to put that on the record.
And I did say that they would run concurrent to each other as well as to any other sentences that Mr. Wilson has served.
Thank you.
In terms of the probation violation files, 04695, 4696, and 4717. We have Mr. Haven here present on behalf of probation and parole. Mr. Haven, how did you want to proceed on those files today?
Well, Your Honor, despite all the violations and violation behavior that he has exhibited, having done no less than 12 warrants being signed by Your Honor, He does have about 407 days of jail credit regarding the probation files. So in light of that and the prison sentences that he's serving, I would ask the court to dismiss the violations.
All right, Mr. Germerthy, anything that you wanted to state for the record in that regard?
No, Judge, as to the probation violation files, all of them, my understanding was that that was going to be dismissed. But I know Mr. Wilson wants to address the court, Judge. I see him raise his hand.
I'm sorry, I didn't see that. Hold on, Mr. Wilson, go ahead. You might have to press something on your end there.
And also, Your Honor, to recommend discharge unsuccessfully on all 3 files.
Oh. Okay, Mr. Wilson, we're able to hear you now.
Yes, now, I don't know if I address you or if I address Ravi about how long and how much credit, because I got 16 months in Crawford, 28 in Gaylord, and 24 at the most in or Crawford, 16 in Roscommon. With so many days credited, I mean, how much time does that break down to? It's crucial for my business. I still get phone calls about estimates and work.
I think that's something that you would have to address with your lawyer, Mr. Wilson.
Is there any possible way we can go into a breakout room after the court's done with me?
I can do that, but I have Mr. Germerthy, I need to have him address one other hearing before we do that. So I can put you in the waiting room, and then when he's done, I can put you two into a breakout room.
Please and thank you.
Okay. All right, so the court will order that the current probation violation be dismissed, that Mr. Wilson be discharged unsuccessfully from probation in each of those files, and that any outstanding fines and costs be preserved. And then, Mr. Wilson, I'm going to put you in the waiting room for a minute, and then I'll have you talk to Mr. Germerthy.
Thank you, Your Honor.
We have Mr. Tremblay's results. Okay, Mr. Tremblay, you can come back up to the podium, please. We'll recall People versus Tremblay.
Sierra Coke on behalf of the people.
Thank you, Honor. Ravi Germerthy on behalf of Mr. Trombley.
Okay, it looks like Mr. Tremblay did test negative. So the court is going to, I'm going to give you another opportunity, Mr. Tremblay. If you would have tested positive today, I would have revoked your bond and sat in jail until your trial date, which is in January. But I want you to understand very clearly that if there are any other failures to test, whether you test positive or not, you're gonna have your bond revoked. You're gonna have to sit in jail. This isn't something that's optional. It's not something to be done if it's convenient. It's not something to be done if you're in town and aren't working. This has got to be a number one, along with all the other conditions of your bond, that you get taken care of. Because sitting in jail and you can't work, you can't do anything else. So the only thing keeping you in jail and being out and doing what you need to do is making sure that you're communicating with Ms. Anderson, not your friends, not your roommates, not your significant others, you personally. That when she calls you, you get in touch with her, and that you follow up with her phone calls. Because again, that's the only thing that allows you to be out and doing the things that you need to do. So Ms. Anderson, what's the next time that Mr. Trombley needs to check in with you? Okay, so before you leave today, just make sure that you check in with Ms. Anderson, the court order that the bond continue. Do we have the next hearing date set?
He is due on 12/18/05 during status at 1:30.
Okay, so December 18th is your next hearing date. Make sure that you stay in touch with Mr. Germerthy as well, so that you're ready to proceed on that date. Okay. Mr. Germerthy, anything further we need to address on this file today?
No, Judge, I would just tell Mr. Trombley to update Ms. Anderson with any current phone numbers or any other numbers he has. So when she does get a hold of him, it is important that she reach him.
All right, thank you. Thank you. All right, and Mr. Grimmerthy, I'm gonna put you into a waiting room with, is that your last case, Mr. Grimmerthy?
That is it, yes, Judge, and then we'll just disconnect from there.
Okay, so I'm gonna put you into a breakout room, with Mr. Wilson, so that you can speak with them.
Mr. Thompson should be on Zoom and Mr. Fowler's should be appearing around.
All right, Mr. Fowler, are you able to hear me okay?
Yes, sir.
All right, and just to confirm, you're Joshua Fowler, is that correct?
I am.
Mr. Thompson, are you able to hear me?
I am, thank you.
All right, we're on the record in People versus Joshua Fowler. This is case number 235206. Record should reflect Mr. Fowler is appearing today by video. Roscommon County. Excuse me, if I could have counsel put your ear.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Joshua Fowler.
This was originally set as an in-person hearing. Have you talked to Mr. Fowler about his rights to have the sentencing hearing in person, Mr. Thompson?
I believe he waived that at the time of the plea, but that's my recollection, Your Honor.
Okay, I wasn't sure, and it does look like that is correct. Okay. Mr. Fowler, have you had a chance to go through the pre-sentence report with Mr. Thompson and talk to him about that?
No, sir.
All right, Mr. Thompson, has there been some kind of issue with getting in touch with Mr. Fowler, or where's the disconnect there?
Yeah, could we have a breakout room, Your Honor?
Yes, we can do that. Hold on one
All right,
second.
thank you.
Just trying to figure out, I have one breakout room open already with different people in it, trying to figure out how to open a second one, so just 1 minute. Mr. Seeger, were you ready?
Case law.
Yeah, so please, this is for 235248.
Your code can be up the people.
Thomas Seaver from Mr. Ellison.
How do we want to proceed?
Your Honor, we would probably just need one final jury status conference, but the matter is likely to proceed to trial. There have been discussions related to a potential resolution. However, at this time, the defendant is not inclined to accept it. Additionally, Your Honor, there was a 404B notice that was filed for which I did find to do some correction. If you wanted a motion form, I can file it in a motion form. If it's one of those situations with the court just
I think if you could file that as a motion. Hearing, then the prosecutor can respond. Sometimes we have to testimony, so I'd rather have that as a motion hearing.
That's fine.
So I think what we'll do is get this on the trial calendar. Aside from addressing the 404B issue, is there any particular amount of time that you would need to be prepared to go forward with trial?
Your Honor, I think I could have the trial with it. I'm not sure where your docket is like here within 90 days. The only thing I would ask the court to do is get someone to take this as a courtesy to the client. Specifically interfere with any other trial dates they may have and guess the time.
Okay. So how many days do you think you're going to be?
One.
I would agree with that.
Okay, so we'll set it for 1 day jury trial. Put it at least 90 days out. The court will set it for a final status conference. That'll be the plea cutoff and motion. So in terms of prosecutor, do you need any other dates set?
No.
Going forward.
We're prepared for trial.
Mr. Seeger?
No, Your Honor.
Mr. Ellison, do you have any questions about how we're going to go forward?
No, Your Honor.
Okay. All right, we'll send out the dates to the parties. Mr. Ellison, it's important that you stay in touch with Mr. Seeger so that you're prepared for that final hearing of the trial. Thank you.
Okay.
Mr. Vernon, are you ready with your case?
We are. Mr. Juarez?
People versus Suarez, case number 235237.
Your code can be up the people.
Adam Byrne on behalf of Marcelo Juarez, who's present over my right. We have received a copy of this.
You had an adequate opportunity to go through that report and talk to Mr. Vernon about that.
Yes, sir.
Mr. Vernon, are there any additions, deletions, or corrections?
So one correction is substance use and treatment section identifies that he used cocaine 1 to 2 times a week from 2023 to 2023. The 1 to 2 times a week was essentially the lowest that he could choose from the list. More accurately, 1 to 2 times a month. We'd ask the court to make that correction.
Under the narrative, it says reports cocaine use around the time of the incident. Is that accurate?
Yes.
And no use since June.
Right, and again, irregular use prior, so, but yes.
So if we change frequency to irregular.
Sure.
We have a category called occasional.
Okay.
Would that be suitable?
Yes.
Okay.
Okay, so we'll correct that to occasional. Okay. Any other corrections?
No. And as far as challenges to the scoring, I don't know if it rises to the level of a challenge, but OB2 identifies the lethal, potential lethality of the weapon. And it's 5 points for possession. I think it's important for the court to understand that the possession was in a duffel bag in the trunk of the car. It's not like it was on his person. It wasn't, you know, he didn't have stuff down his belt or in his, under his coat or anything like that. I understand that legally that constitutes possession, but I think there's a very big difference between having it on his person and having it in a duffel bag stored in a trunk that he didn't have any access to when he encountered the police or any other person on that day. So I just want that to be made aware.
All right, I think that's more of an issue of allocution, pointing out mitigating factors. I don't find that would be a basis to not score OB2, so to the extent that it's a challenge, the court will order that OB2 remain scored at 5 points. Any other challenges?
No additional solutions or other challenges?
Let's go if people have any additions, solutions, or corrections.
No, Your Honor.
Any challenges to scoring in the guidelines?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, drugs and money is always a bad combination. I'm sorry, drugs and weapons. Mr. Wars is young. He doesn't have very much of a criminal history. He's 20 years old. The recommendation, I believe it's 10 days in jail with 2 days credit. I think it's appropriate for some minor sanction, and I'd ask the court to follow the recommendation. Thank you.
And we're asking the court to waive the 10 days jail. Probation period of 18 months is going to give Mr. Flores every opportunity to make amends to the community and to learn from his behavior. He is a young man. He got involved with, you know, the cocaine essentially as a coping mechanism for work. The presence of the cocaine and the gun together obviously had a bad appearance. They weren't present for the same purpose. He acquired the gun and thought it was cool, so he had it with him. Never used it. There were bullets were in the magazine, but there was nothing in the chamber. Again, it wasn't in the spot where he could use it or inflict any harm or threats or coercion over other people. It was essentially safely stored. The reality of, again, the cocaine and the gun together, it's a bad impression, but I don't think if you look at all the facts and circumstances, it warrants an incarceration. He's got 18 months to prove that this was, you know, a juvenile-like mistake and just a childish error, and putting these things in his possession and having them in the car. Consistent with the description that he put in the recommendation is that if the cocaine use was irregular or occasional use, it wasn't something that he was doing on the regular or that was going to interfere with his ability or cause him to commit other crimes, which is often what this court finds is the use of drugs compels people to commit other crimes. Again, that's not what we have here. So he is gainfully employed. He is going to continue to do that. He is working. So I would ask the court to consider that the probation. We would ask the court to impose the 18 months of probation and whatever services the court desires are appropriate there. But in the guidelines, you know, in a 0 to 6 months, with the only other offense being a juvenile receiving and concealing, where basically he possessed a phone somebody gave him that he didn't know had been stolen until later. I think that this, as a first offense that's appropriate for 7411, we should be focusing on treatment and services and not the penalties. I would ask the court to do that.
Thank you. Mr. Juarez, is there anything that you wanted to say?
I feel like it was a bad decision on my part. It's not a good look. I wanted that good on guns and drugs is not a good look, and I shouldn't have had it in the first place. I just want to apologize for that happening. I just think it was a bad decision on my part.
I read through the pre-sentence report in this case, so I'm familiar with the circumstances that bring you before the court. There's also a lot of information in there about your background and circumstances as well. So I take all of that into consideration along with what say here. This is a really concerning circumstance. You're involved with some serious substances, and I agree when you talk about putting weapons into the mix there, whether or not it was directly in your possession or just in the vehicle, or the reason for that, it is not a good combination. And it can lead to dangerous and bad results for you and for other people. Or it has significant interest in discouraging and deterring you from engaging in that kind of conduct and other people as well. You don't have any adult record. You had one issue, it looks like, as a juvenile, where you had some probation there. I think probation here is definitely appropriate. And I think pursuant to 7411, given your age and lack of adult criminal history at this time, that's also appropriate to give you an opportunity through probation, have this come up with your record. And that's going to be really important for you going forward. So the court is going to place you on probation pursuant to all the terms and conditions listed here. I also think that a few days in jail might do some good for you. I make a short sentence, and I think the recommendation is geared directly towards that. Somebody your age, never really been to jail before, first time getting into trouble, having a couple days to sit in the jail and see what that's like, I think will make a big impression on you and hopefully convince you that that is not the way that you want to go, and provide motivation for you to comply with your probation and move on. That's not get involved in this kind of thing again. And so I agree with the recommendation for that as well. So the court is going to place you on probation for a period of 18 months pursuant to 7411. Court is going to adopt as the terms and conditions probation, all the terms and conditions listed within the report. The court is going to order that you serve 10 days in the Crawford County Jail. You have credit for 2 days served. Crime victims assessment of $130. Court cost of $325. $68 state cost, and a supervision fee while you're on probation of $30 per month. Because this is pursuant to, there are no written appellate rights. Scope, is there anything else that we need to address?
No, thank you.
Mr. Burns? No. Mr. Juarez, you're remanded to the custody of the county at this time. All right, Mr. Thompson, are you ready to proceed with Mr. Fowler's case?
Yes, thank you.
We're back on the record in People versus Fowler. Mr. Fowler, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, sir.
Are you ready to proceed with sentencing at this time?
I am.
Mr. Thompson, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
There's no scoring, so no.
Oh, I'm sorry. Correct, I see that. Okay. Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
The people's reality.
The court is familiar, well, I'm sure with the contents of the PSI. I don't think have anything additional to add. I think Mr. Fowler with 3 felonies and 18 misdemeanors is probably not likely to do super great on probation. I'd ask the court to follow the recommendation.
Thank you, Mr. Thompson.
Thank you, Your Honor. In terms of the recommendation regarding no probation, we are in agreement with that, Your Honor. It's within the court's discretion what the jail sanction is. We understand the recommendation. We would ask if the court would consider a 6-month sanction instead. And I don't know if the court has any authority over this, but Mr. Fowler is currently in Roscommon. He's awaiting, he has a charge there that he is meeting. He would just as soon remain lodged in Roscommon. But again, I don't know if that's within the court's purview. So that would be our statement for sentencing, Your Honor.
All right, thank you. Mr. Fowler, anything that you wanted to state today?
No, sir. Like my lawyer said, I would just like to stay here in Roscommon. I do have a open case going here too, so that's all I would request is just to stay here in Roscommon.
All right, thank you. I had a chance to review the pre-sentence report in this case. I had a chance to, through that report, become familiar, Mr. Fowler, with your circumstances and background, as well as the circumstances of this particular case. And I think it, you know, the report does a good job of kind of summing up both your history as well as what happened here that brings you before the court today. In terms of what is an appropriate sentence, certainly your background and history is problematic. You've got 18 prior misdemeanors, 3 prior felonies, a number of jail sentences. You've been on probation 6 times. In my view, I agree with the recommendation for straight jail. I don't think at this point any further community resources to probation in this case is going to be helpful to either you or to the community. So the court is looking strictly at a jail sentence. Given your conduct in this case, the circumstances surrounding the methamphetamine that you were found with, as well as your behavior directed at law enforcement during the encounter, I do think that a sentence at the top of the guidelines or the top of the range is appropriate in this case. The court is going to sentence you to 1 year in the Crawford County Jail. You don't have credit for 50 days served. Court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $118 state costs. The jail sentence is as to counts 2 and 4 that's to be served concurrent to each other. Mr. Fowler, I don't have any objection to you serving your time in Roscommon there. I'm not sure what the jail would need, but if Roscommon jail needs something from me, I'd be happy to sign any kind of orders or whatever would be required for you to serve your time there in Roscommon, but I don't have any objection to that. You do have the ability to appeal this sentence. If you wanted to file an appeal because they're misdemeanors, you won't get any paperwork explaining what your appellate rights are, but you would need to file for an appeal within the next 21 days. So there is a time limit on that. If you had further questions about that, I'm sure Mr. Thompson would be able to answer those questions for you. Ms. Cope, is there anything further that we need to address for the record?
No, thank you.
Mr. Thompson?
Nothing further for the record, thank you.
Okay, that's all for today. Mr. Fowler, you are remanded to the custody of the county at this time.
I have no
Ms.
idea.
Cope, anything about Mr. Dickinson?
Oh.
The case that's tonight.
I have a letter. Let me look at the notes real quick. The Guardian.
That's district court file number 2317175.
There was a offer made. That's as far as the notes go.
District court Bailey question, I don't.
It's not a question for Bailey, it's her stepson.
But district court.
Okay.
No, I didn't know if they could.
Nope.
That I'd start dealing.
I'm not aware of that case.
All right, Ms. Cope, can you just check with this recorder to see what that's set for a status conference on my docket?
At 11:45, right?
Yeah.
Yep, okay.
Yeah, I know it's about the same.
Yep. So you don't have to set up a view. I already have it up.
Yeah.
Take it back. You're already set up.
Yeah.
I'll just.
You could just, I'll just leave it. I'll just put it out. It's not gonna be like.
Well, I'm done with court.
Oh, you're not. Okay. I mailed notices to her.
That's not set until
Yeah.
11:45, so we'll just take a short recess.
Yeah.
See what happens. Okay, we're on the record in People versus Dakota. John Dickinson, case number 2317175, district court case number. I'm sitting on this matter by assignment. If I could have counsel for your appearance on the record.
Yes, Dana Chady on behalf of the people.
This is set for a status conference in this matter today. It was set for 11:45. I don't see Mr. Dickinson present in the court. Has the prosecutor's office had any contact with him or anyone on his behalf?
No, Your Honor, I've sent mailings to him. I've called the number that we had for his guardian 2 times prior to this date. I have not heard from either of them. I would request that we set this for another jury status conference. I have tendered an offer. I don't know if they've received it. I don't know if they're just ignoring my communications at this point.
Okay. How much time do you want to be able to do that? What would you like to request for it to set that?
Your Honor, I don't have a specific time in mind. I know I'm open to whatever's on the court schedule. Prior to this date, I did tender an offer and try to communicate multiple times. So I would leave it up to your discretion on how much more time we want to give to the guardian or defendant to take advantage of the offer or communicate with the court.
Okay, so the court will set this for a show cause and status conference on December, so early December. If Mr. Dickinson doesn't appear, we don't have any communication from him or anyone on his behalf. That's definitely look at it. Do that given the circumstances and deficits of Mr. Dickinson, but this case on, so.
Yes.
Okay, anything further for the record?
No, Your Honor. Thank you.
Thank you. That concludes